Since the final revisions to the Federal Fair Housing Act in 1988, we have been obligated to protect the 7 classes. In 1991, the Americans with Disabilities Act was passed, which, among other things, gave us some guidance on the rules when attempting to rent a property to a handicapped person. Between 1988 and 1991, there was some confusion, but essentially, the Act states that a landlord is not obligated to go to extraordinary lengths to accommodate a handicapped person, but must allow the handicapped person the right to make any reasonable changes to the property to accommodate his or her needs. The landlord is not obligated to cover the expense, and the landlord can require that the tenant restores the property when vacating, at the tenant's expense. So, today, under the federal law, with the 7 protected classes, what are the guidelines for real estate agents so that they are in compliance with the rules? First, learn the laws and the protected classes, as well as the definitions of who would qualify to be in a protected class. The 7 classes forbid discrimination based on race, religion, color, sex, gender, national origin, handicapped status, familial status. The last 2 protected classes, handicapped status and familial status, were added to the federal fair housing laws in 1988. Handicapped status is defined as having a physical or mental impairment which substantially limits one or more of such a person's major life activities. Having a record of having such an impairment, or being regarded as having such an impairment, but such term does not include current, illegal use of or addiction to a controlled substance, as defined in Section 102 of the Controlled Substances Act. So anyone with a disabling function, such as being partially or fully blind, deaf, unable to walk or talk, or any other impairment that would affect a major life activity, would be considered handicapped under this law. A family was defined as a household consisting of any adults over the age of 18 and child under the age of 18, where the child is a permanent resident. And remember that NAR added the 8th protected class, sexual orientation, on January 1, 2011, and the 9th protected class on January 1, 2013. There is often confusion about the law regarding rentals and both the handicapped and the familial status classes. There are numerous situations where a landlord could reject a tenant, even if the tenant or one of the tenants was a member of a protected class. For example, consider a married couple, both Middle Eastern, yet the husband has a criminal record. The landlord could reject the lease based on the criminal record, but not based on the fact that they were Middle Eastern. Furthermore, all the parties to any lease, regardless of the fair housing laws, must legally be able to execute a lease. Thus, a 17-year-old black woman could be rejected because she is a minor, not because she is black. Why would I capitalize one and not the other? Well, they both mean different things. Black capitalized is the ethnic diversity of the person, and black not capitalized would just be her color. Either way, she cannot be discriminated against for those reasons. Could a landlord require that all tenants be U.S. citizens, or show documents of their legal status? Yes, that could be a requirement that the landlord imposes on all possible tenants. Upon what grounds may a potential landlord justifiably reject an application? Rejection of a housing applicant is justified if that applicant cannot meet the obligations that apply to all tenants. The basis for such a rejection must be upon recent, credible, and objective data that demonstrates the applicant's inability to meet general requirements. For example, a landlord may reject applicants upon a showing of insufficient income or current or previous conduct. Regarding a disabled applicant, a potential landlord may not reject an application on the basis of an individual's disability. Likewise, a landlord may not refuse to rent to an individual with a disability because that individual requires occasional support or services in order to live independently. However, an individual with a disability may be refused tenancy if it would pose a direct threat to the health or safety of others, or would result in substantial physical damage to the property of others. To merit refusal on this basis, a landlord must possess objective evidence of such a threat. But a potential tenant with a disability may not be rejected if a reasonable accommodation would enable that individual to comply with the landlord's general standards or eliminate any potential threat. A reasonable accommodation is a change in rules, policies, or practices where the need for such a change is related to one's disability. For example, a landlord must accommodate a person who is visually impaired and uses a seeing eye dog by modifying the no pets policy, unless the landlord can show that such an accommodation is an undue burden or would cause a fundamental alteration in the housing provided. Particularly where a rule is silly or a barrier to housing, courts may be inclined to require a reasonable accommodation. Although an individual's disability is often related to that person's finances, discrimination on the basis of one's source of income has been permitted, absent a state statute to the contrary. Generally, courts have relied upon two substantive arguments in rejecting discrimination claims based on financial criteria. First, save the few states where discrimination based upon source of lawful rent is prohibited, courts have held that discrimination based on financial criteria is not discriminatory. Second, courts have found that because financial status is not directly linked to an individual's disability, a reasonable accommodation cannot be forced on that basis. In Chancellor's Village Apts, 998 F. Suppert, 784, ed. Mic. 1998, the court held that a guarantee of rent did not constitute a reasonable accommodation because there was no direct correlation between the plaintiff's disability and his poor financial situation. Similarly, in Salute v. Stratford Greens Garden Apartments, 136 F3D 293, 2D Surmer 1998, the court reasoned that the reasonable accommodation provision of the FHA did not require a landlord to accept a Section 8 voucher from tenants with disabilities, even if it accepted such vouchers from tenants without disabilities, because such an accommodation does not meet and fit their particular handicap. However, as the dissenting opinion in Salute points out, often the link between disability and financial situation is clear. Therefore, the question should be framed as whether the individual is a person with a disability who happens to be poor, requiring Section 8 assistance, or whether the individual is poor and dependent on Section 8 assistance precisely due to her disability. Because courts have yet to recognize that the correlation between disability and financial situation is clear, under current law, discrimination based on financial criteria is acceptable under the FHAA, regardless of disability status. Furthermore, federal law does not require landlords to accept Section 8 vouchers. In requesting an accommodation, the individual has disclosed that he or she has a disability. If the disability is not apparent, the landlord may ask for verification that the tenant has a disability as defined by the Fair Housing Act. No additional inquiry into the nature or extent of the disability beyond establishing the need for the accommodation is allowed. Think about this. If a person with a non-apparent disability walks into a store with a dog that does not have a service vest on, and the store inquires about the reason for the dog, the store could be sued. They may have the dog for sensing a seizure coming on.